Their appearances for the record.
Jimmy Gessington from Searcy, Denney, Scarola, Barnhart, and Shipley.
Greg Barnhart from the same law firm.
David Sales from the law offices of David Sales.
Ursula Henninger from King and Spalding, representing R.J. Reynolds Tobacco Company.
Your Honor, Frank Bay from King and Spalding for R.J. Reynolds. Philip Green from King and Spalding for R.J. Reynolds.
Okay. Good morning, everyone.
We'd like to introduce our client, actually.
Okay.
We had Bob Wilcox and this is Lorraine Wilcox right now. This is Judge Norma Lindsay.
Good morning.
She has vision problems, so she can't quite see you.
That's all right. Good morning.
Your Honor, before we adjourn, we do have an issue. We would invoke the rule, and because Mr. Robert Wilcox is the plaintiff under the law of the case, the state rep, we've asked that Mrs. Wilcox be excused until she's called to testify. Your Honor, Mrs. Wilcox is the sole survivor of her husband's estate. She's a plaintiff in this case. She is a party in this case, and she has a right to be here. Your Honor, I have a case law directly on point. Again, a copy. It is Benjamin versus Camden Healthcare out of the 4th District.
The rule of sequestration. Hang on.
I'm not done yet.
Not to move. Just a second.
Your Honor, I'm not sure if your copy is highlighted, but the pertinent portion is on page 6 of this packet. Under heading 8, we're discussing a point in this appeal of whether it was proper to exclude the survivors in the wrongful death lawsuit from the courtroom, as the trial court did. And the court goes on to say that in a wrongful death case, the representative of the estate is the proper plaintiff, the proper party in interest. The survivors, in this case, 4 children, were not plaintiffs, were not parties under the rule. The rule is very clear. It's Evidence Code 90.616. I think this case is directly on point and directly refutes what Mr. Justin is arguing.
I'd like to be heard when Your Honor is prepared.
Okay, I've reviewed the case. Go ahead.
The important point of the holding from occupying the position that I usually occupy in these cases is the last highlighted portion. As such, we conclude that the party for the purposes of the sequestration rule was Benjamin, so that would be Mr. Wilcox, as personal representative of the estate, and the trial court did not abuse its discretion in excluding children. Okay. So the first question is, does Your Honor have discretion to allow a 90-year-old surviving widow to sit here? And I would just point out for the court, as Your Honor can appreciate, that because of Mrs. Wilcox's age and the relative wellness and health of her children, they are occupying the position of her personal representative, of her as personal representative. She's not a child. She's a grown person. And the only reason that she's not the personal representative is because it's more responsible in a setting like this when we have older parents or grandparents to put somebody else in charge. This is a matter of discretion for the court. And she has come down here from home in order to sit through these proceedings and participate in them as a party would. Technically, counsel is right. She is not the party. But the matter is one of discretion for the court on their own authority. Your Honor is not going to be reversed for this. I'm confident if Your Honor allows the only interested party in the case to sit through this trial. We ask that Your Honor exercise Your Honor's discretion to allow the widow to sit.
Your Honor.
Will she be providing testimony?
Well, that is a whole separate issue, Your Honor, as to whether or not she should be excluded when people testify. And I haven't discussed it with Mr. Gustafson.
She will testify.
She will testify.
All right. Anything else from defense?
I would just add very quickly, Your Honor, the rule is not discretionary. The rule clearly states that Your Honor shall order the exclusion of witnesses when requested by the party.
Okay.
There is no discretion.
All right. She will be excluded from testimony until after she testifies herself, and you have stipulated on the record that she is not intended to be called in rebuttal in any way.
All right. But it does apply to testimony. Presumably she can sit for openings since she's here.
I think the lawyer on speaks to
90.616, the same thing the counsel just read, excluded from a proceeding so they cannot hear the testimony of other witnesses. That's the statute upon which they rely. It doesn't apply to opening statement.
I can tell you when we invoke this rule, judges, in my experience, uniformly impose it to all aspects of the proceedings. Jury Earhart also talks about excluding non-parties from hearings. So it is broadly encompassing. I'm certain there is going to be witness testimony summarized in opening, and the better course and the purpose of the rule, which is to prevent witnesses' testimony from becoming tainted, is to exclude her from the courtroom until she offers testimony.
All right. Plaintiff, your opening will include references to what the testimony will be in the case.
The opening is going to include what the evidence has been developed thus far. Yes, ma'am.
All right. Then I think she should be excluded from openings because testimony will be proffered.
Counsel, most respectfully, misstated what Earhart said. I assume he's talking about this, Your Honor. Sequestration is most frequently invoked at a trial after the opening statements of counsel. It is also appropriate in the pretrial hearings in which witnesses are called, for the obvious reason so that when witnesses testify at the hearings, that their testimony cannot be influenced by the testimony of others.
Okay.
Your Honor, I've tried a lot of work with that case. We deal with the rule all the time, but not an opening statement because it's not evidence. You'll tell the jury that it's not evidence.
How are you prejudiced, defense?
I'm sorry.
How are you prejudiced if she sits here?
Because Mr. Gustin is going to talk for an hour and a half this morning, summarizing all of the evidence in the case, what the fact witnesses will say, what the expert witnesses will say. It is no different than if the witness were to sit here for those people that come testify on it. The purpose of the rule is to prevent witnesses from hearing what other witnesses are going to say so that it doesn't impact their testimony. That's the fundamental basis of the rule.
Okay.
I repeat it before you will tell this jury that what Mr. Gustafson says probably a sentence or so is not evidence. It's nothing. The rule is designed for one witness hearing questions directed to another, testimony.
All right. If you can proffer to me that there will be no statements in opening to the effect of, you will hear this witness testify to this witness testify to this witness will tell you.
Well, there probably will be that, but it's not testimony, Judge. It's not evidence. It's just what the lawyers anticipate will happen. So what they're doing is they're taking the rule and carrying it from what the rule says to the ridiculous extreme. And I have yet, not been holding for a long time, I've got a lot of wrongful death cases. I have yet to have a judge keep out the widow if one of the grown children is the personal record. Now, once the trial starts, yes, but not for open statement.
Here's the problem with that. Regardless of what they do, we are going to do that in our own. And as Your Honor, we discussed at the pretrial hearing, the purpose of the opening is to tell the jury what the evidence will be. There is no argument. So all of the opening is what the evidence is going to be. That's why we have the problem.
All right. The rule says from a proceeding, they've invoked the rule. They've proffered that they will be proffering evidence in their opening. I think they're entitled to have her excluded.
Your Honor, since the defense insists on that, we would like it made perfectly clear what the court's ruling is about the rule of sequestration. They cannot show their experts transcripts. They can't tell their experts what's been said in this courtroom. They can't do any of that.
We agree, and it should apply to both sides.
All right. So we have a stipulation on that.
We have further relief, Your Honor. If I were sitting on the jury, I would want to know why, if I got to sit here, why the party who's going to get the money if they win is not sitting there. We would ask the court to tell the jury that the court has excluded Mrs. Wilcox, not at the defense's request. Obviously, that's not important, because it's unfair to create impression that she doesn't care enough to be here, which is what I would think if I were on the jury.
Your Honor, Mr. Sales fortunately isn't on the jury. I think it's clear from the instructions we just hashed out for the last hour that this is a case brought by Mr. Wilcox. The jurors who we spent all last week picking were not confused by that when Mrs. Wilcox was not here.
Okay. I think given the number of individuals sitting in and around all areas of the courtroom, it's important to tell the jury that there are many people here, but no one who will testify as a witness in the case other than Mr. Wilcox, because he is the personal representative, is allowed in the courtroom at this time.
That's fine.
So that they understand that it is an open courtroom, but that witnesses are not present amongst the many people that are in the courtroom. And I don't know everyone who is in the courtroom. Both sides, can you represent to me that there are no witnesses in the courtroom?
There are no witnesses in the courtroom from the defense, Your Honor.
And Your Honor will give that instruction.
All right. Anything else before we start?
Judge, I just also confused.
Yes. Can everyone hear me okay? Okay, is everyone ready? Before we bring everyone in, does everyone have things arranged as to where they want to stand? And
Yes, I'm going to bring the podium back over so we don't stand in front of
okay. Anything else before we bring in the jury? Madam Court Reporter, are you all ready? All right, just a minute till they. Mr. Gustafson, about how long do you have for your opening, do you think?
an hour and a half, maybe a little bit more.
All right. So then, given the time frame after your opening, we'll take a lunch break.
However you want to do it.
All right. Defense, you'll go after lunch.
Thank you.
All right, our court reporter is ready. Everyone else ready? Victor, please bring in our jury.
All right.
Good morning, ladies and gentlemen. Everyone, please be seated. Members of the jury, good morning. Thank you all for being back promptly with us. You've now taken an oath to serve as jurors in this trial. Before we begin, I'm going to tell you about the rules of law that apply to this case and let you know what you can expect as the trial proceeds. It is my intention to give you most of the rules of law, but it might be that I will not know for sure all of the law that will apply in this case until all of the evidence is presented. However, I can anticipate most of the law and give it to you at the beginning of the trial so that you will better understand what to be looking for while the evidence is presented. If I later decide that different or additional law applies to the case, I will tell you. In any event, at the end of the evidence, I will give you the final instructions on which you must base your verdict. At that time, you will have a complete written set of the instructions, so you do not have to memorize what I'm about to tell you. Let me give you a summary explanation of some of the issues in this case. As I mentioned earlier, the plaintiff in this case is Robert Wilcox as the personal representative of the estate of his late father, Cleston Wilcox. The defendant in this case is R.J. Reynolds Tobacco Company. There was an earlier lawsuit which began in 1994 that was brought as a class action on behalf of all Florida smokers who met certain requirements. That lawsuit is commonly referred to as the Engle case. As part of that lawsuit, the Florida Supreme Court determined in 2006 that individuals who claimed that they were members of that class were permitted to file their own individual lawsuits. This is one of those lawsuits. I'd also like to, now that you've been sworn, give you an idea about what we're here to do today. This is a civil trial. A civil trial is different from a criminal case where a defendant is charged by the state prosecutor with committing a crime. The subject of a civil trial is a disagreement between people or companies where the claims or one or more of these parties have been brought to court to be resolved. This is a wrongful death case brought by the plaintiff, Robert Wilcox, as personal representative for the estate of his father, Cleston Wilcox. The defendant in this case is R.J. Reynolds Tobacco Company. Plaintiff claims that Cleston Wilcox's death was caused by an addiction to defendant's cigarettes containing nicotine. Plaintiff seeks to recover damages based on his claim that Reynolds engaged in wrongful conduct or marketed cigarettes with a defect that was a legal cause of Mr. Wilcox's lung cancer and death. Plaintiff contends that Mr. Wilcox's own acts or omissions related to the frequency and duration of his efforts to quit smoking, in combination with the acts of Reynolds and other cigarette companies, were a legal cause of his lung cancer and death. Plaintiff also contends that Reynolds' conduct warrants punishment in the form of punitive damages. Reynolds denies all of plaintiff's claims and further denies that plaintiff is entitled to any damages or any other relief in this action. Reynolds contends that Mr. Wilcox made an informed decision to smoke and chose to continue smoking long after he was aware of the health risks of smoking. And now we'll let you know what you can expect as the trial proceeds. Opening statements. In a few moments, the attorneys will each have a chance to make what are called opening statements. In an opening statement, an attorney is allowed to give you his or her views about what the evidence will be in the trial and what you are likely to see and hear in the testimony. Evidentiary phase. After the attorney's opening statements, the plaintiffs will bring their witnesses and evidence to you. Evidence is the information that the law allows you to see or hear in deciding this case. Evidence includes the testimony of the witnesses, documents, and anything else that I instruct you to consider. A witness is a person who takes an oath to tell the truth and then answers attorneys' questions for the jury. The answering of attorneys' questions by witnesses is called giving testimony. Testimony means statements that are made when someone has sworn an oath to tell the truth. The plaintiff's lawyer will normally ask a witness the questions first. That is called direct examination. Then the defense lawyer may ask the same witness additional questions about whatever the witness has testified to. That is called cross-examination. Certain documents or other evidence may also be shown to you during direct or cross-examination. After the plaintiff's witnesses have testified, the defendant will have the opportunity to put witnesses on the stand and go through the same process. Then the plaintiff's lawyer gets to do cross-examination. The process is designed to be fair to both sides. It is important that you remember that testimony comes from witnesses. The attorneys do not give testimony, and they are not themselves witnesses. Objections. Sometimes the attorneys will disagree about the rules for trial procedure when a question is asked of a witness. When that happens, one of the lawyers may make what is called an objection. The rules for a trial can be complicated, and there are many reasons for attorneys to object. You should simply wait for me to decide how to proceed. If I say that an objection is sustained, that means the witness may not answer the question. If I say that the objection is overruled, that means the witness may answer the question. When there is an objection and I make a decision, you must not assume from that decision that I have any particular opinion other than that the rules for conducting a trial are being correctly followed. If I say a question may not be asked or answered, you must not try to guess what the answer would have been. That is against the rules too. Sidebar conferences. Sometimes I will need to speak to the attorneys about legal elements of the case that are not appropriate for the jury to hear. The attorneys and I will try to have as few of these conferences as possible while you are giving us your valuable time in the courtroom. But if we do have to have such a conference during testimony, we will try to hold the conference at the side of my desk so that we do not have to take a break and ask you to leave the courtroom. Recesses. Breaks in an ongoing trial are usually called recesses. During a recess, you will still have your duties as a juror and must follow the rules, even while having coffee at lunch or at home. Instructions before closing arguments. After all of the evidence has been presented to you, I will instruct you in the law that you must follow. It is important that you remember these instructions to assist you in evaluating the final attorney presentations, which come next, and later during your deliberations to help you correctly sort through the evidence to reach your decision. Closing arguments. The attorneys will then have the opportunity to make their final presentations to you, which are called closing arguments. Final instructions. After you have heard the opinions about any part of the case. It would be wrong for you to conclude that anything I say or do means that I am for one side or another in the trial. Discussing and deciding the facts is your job alone. Note-taking by jurors. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pad for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the trial, you may have a question you think should be asked of a witness. If so, there is a procedure by which you may request that I ask the witness a question. After all the attorneys have completed their questioning of the witness, you should raise your hand if you have a question. I will then give you sufficient time to write the question on a piece of paper, fold it, and give it to the bailiff, who will pass it to me. You must not show your question to anyone or discuss it with anyone. I will then review the questions with the attorneys. Under our law, only certain evidence may be considered by a jury in determining a verdict. You are bound by the same rules of evidence that control the attorney's questions. If I decide that the question may not be asked under our rules of evidence, I will tell you. Otherwise, I will direct the question to the witness. The attorneys may then ask follow-up questions if they wish. If there are additional questions from jurors, we will follow the same procedure again. By providing this procedure, I do not mean to suggest that you must or should submit written questions for witnesses. In most cases, the lawyers will have asked the necessary questions. Class membership. The first issue for your determination on plaintiff's claim will be whether Cleston Wilcox was a member of the Engle class. To prove that Cleston Wilcox was a member of the Engle class, the plaintiff must prove by the greater weight of the evidence that Mr. Wilcox died from lung cancer caused by an addiction to cigarettes containing nicotine. Greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Legal cause. An addiction to smoking cigarettes containing nicotine is a legal cause of injury if it directly and in a natural and continuous sequence produces or contributes substantially to producing such injury so that it can be reasonably said that, but for an addiction to cigarettes containing nicotine, the injury would not have been suffered. Plaintiff has admitted that Mr. Wilcox was partially responsible for causing his own injuries and death. Specifically, plaintiff has admitted that Mr. Wilcox's own acts or omissions related to the frequency and duration of his efforts to quit smoking were a legal cause of his cancer and death. Engle findings. If the greater weight of the evidence does not support the plaintiff's claims on this first issue, then your verdict is for R.J. Reynolds. If, however, the greater weight of the evidence does support the plaintiff's claims on this first issue, you shall address the remaining claims by the parties. If you find that Cleston Wilcox was a member of the Engle class, you must apply certain findings from the original action brought in 1994. These findings are binding upon you, the court, and the parties. The findings may not be denied or questioned, and they must carry the same weight they would have if you had determined them yourselves. The established findings are: 1. Smoking cigarettes causes numerous diseases, including lung cancer. 2. Nicotine in cigarettes is addictive. 3. R.J. Reynolds Tobacco Company was negligent. 4. R.J. Reynolds placed cigarettes on the market that were defective and unreasonably dangerous. 5. R.J. Reynolds concealed or omitted material information not otherwise known or available, knowing that the material was false and misleading, or failed to disclose a material fact concerning or proving the health effects and or addictive nature of smoking cigarettes. 6. R.J. Reynolds entered into an agreement to conceal or omit information regarding the health effects of cigarettes or their addictive nature with the intention that smokers in the public would rely on this information to their detriment. These findings are only binding on you and only relevant to this case if you find that Cleston Wilcox was a member of the Engle class. The findings establish only what they expressly state, and you must not speculate or guess as to the basis for the findings. Comparative negligence. If the greater weight of the evidence supports that Cleston Wilcox was a member of the Engle class, then you shall consider the extent to which Mr. Wilcox's negligence was a legal cause of his lung cancer and death. Negligence is the failure to use reasonable care, which is the care that a reasonably careful person would use under like circumstances. Negligence is doing something that a reasonably careful person would not do under like circumstances, or failing to do something that a reasonably careful person would do under like circumstances. Fraud by concealment. The court has instructed you that R.J. Reynolds concealed or omitted material information about the health effects or addictive nature of its cigarettes or both. The issue for your determination on plaintiff's claim for concealment is whether the concealment or omission of material information by R.J. Reynolds was a legal cause of Cleston Wilcox lung cancer and death. The concealment or omission of a material fact is a legal cause of lung cancer and death if it directly and in natural and continuous sequence produces or contributes substantially to producing the lung cancer and death, so that it can be reasonably said that, but for the concealment or omission, the lung cancer and death would not have occurred. Conspiracy. The court has instructed you that R.J. Reynolds agreed with other tobacco companies and organizations to conceal or omit material information about the health effects or addictive nature of cigarettes or both. The issue for your determination will be whether this agreement to conceal or omit material information was a legal cause of the lung cancer and death of Cleston Wilcox. The agreement to conceal or omit material information regarding the health effects of cigarettes or their addictive nature is a legal cause of lung cancer and death if it directly and in natural and continuous sequence produces or contributes substantially to producing such lung cancer and death, so that it can be reasonably said that, but for the agreement, the lung cancer and death would not have occurred. Wrongful death damages. If your verdict is for the defendant R.J. Reynolds, you will not consider the matter of damages. But if the greater weight of the evidence supports any of plaintiff's claims, you will be asked to determine and write on the verdict form in dollars the total amount of damages which the greater weight of the evidence shows Lorraine Wilcox sustained as a result of her husband's death, including any damages he is reasonably certain to incur or experience in the future. In determining the damages recoverable on behalf of Cleston Wilcox's estate, you shall consider the following elements. In determining any damages to be awarded, Lorraine Wilcox's personal representative for the benefit of Mr. Wilcox's wife, Lorraine Wilcox, you shall consider certain elements of damages for which there is no exact standard for fixing the compensation to be awarded. Any such award should be fair and just in the light of the evidence regarding the following elements. Lorraine Wilcox's loss of Cleston Wilcox's companionship and protection and her mental pain and suffering as a result of Mr. Wilcox's injury and death. In determining the duration of the losses, you may consider the joint life expectancy of Robert Wilcox and Cleston Wilcox together with the other evidence in this case. Entitlement to punitive damages. You should consider whether, in addition to compensatory damages, punitive damages are warranted as punishment to R.J. Reynolds and as a deterrent to others. I will give you additional instructions, after which you will decide whether, in your discretion, punitive damages will be assessed, and if so, the amount. Okay, ladies and gentlemen, that concludes my introductory instructions. I want to let you all know this is a public courtroom. You may see people come in and out of the courtroom. That is allowed. However, individuals who will be testifying in the case are not present in the courtroom at this time. Plaintiff, you may proceed. Mr. Gustafson? Yes.
Good morning. The rules in this trial have now changed, as Her Honor just told you. Now we get to talk with you about what we believe you're going to be seeing and hearing as evidence in this trial. May it please the Court.
Yes, Victor is going to pass out the notepads.
Now, Your Honor.
Go ahead.
A company is never allowed to conceal or lie about a danger that it knows about in its product. If a company does that, and as a result of it someone is harmed, then the company is responsible for the harm that it caused.
Objection, Your Honor. Argument.
Overruled.
Let me tell you now what happened in this case. R.J. Reynolds sold defective and unreasonably dangerous cigarettes. The evidence is going to show that R.J. Reynolds knew that its cigarettes caused cancer and other diseases when used as they were intended to be used, and that R.J. Reynolds lied about it. The evidence is going to show you that R.J. Reynolds knew that their cigarettes were addictive, that R.J. Reynolds designed their cigarettes to be addictive, and they lied about that too. And the evidence is going to show you that R.J. Reynolds knew that their customers would get addicted if they inhaled cigarettes the way they were designed to be inhaled, and that as a result of that inhalation of the smoke, they would become addicted. And addiction would lead to what their own previously secret documents call unattractive side effects, like lung cancer, emphysema, and heart disease. And they lied about that too. And the evidence is going to show you that while R.J. Reynolds calls smoking a choice, they were experimenting with adding things to cigarettes to try to increase the effect of nicotine on the user. And you'll learn in this trial that what happened to Cleston Roy Wilcox and really his generation was the result of a nationwide effort by R.J. Reynolds and the other cigarette companies who publicly promised to look out for their customers and had a duty, certainly, not to endanger their customers' lives, certainly not to conceal dangers that they knew about from their customers. Mr. Wilcox smoked a pack or more a day for 34 years before the first caution label was placed on a pack of cigarettes in 1966. 34 years. The evidence is going to show you that Mr. Wilcox had long been addicted, like millions of other smokers, and that he died from lung cancer caused by smoking. The defendant, R.J. Reynolds, is going to tell you most of this story. They're going to tell us what they knew and when they knew it. They're going to tell us what they did and why they did it. And they're going to tell us that what they did worked. We're going to prove this case with the words of the defendant and the other cigarette companies that it conspired with with their own previously secret documents, things that they never intended for the rest of us to see. And the evidence is going to show there has never been a product in history like the rise of the modern cigarette. One day, cigarettes were hardly used, and 20 years later they were being consumed by the billions. Almost overnight, consumption of the modern cigarette dwarfed the use of every other tobacco product: cigars, pipes, snuff, chewing tobacco, all of it. This is a graph showing the amount of cigarettes that were used, the billions of cigarettes smoked per year in this country between 1900 and 1912. Because at the turn of the century, there weren't many people smoking cigarettes. There were no modern, mass-produced cigarettes. There were no Camels, no Lucky Strike, no Salem. There were no mass-produced matches that you could light cigarettes with. And there were no mass marketing of cigarettes. There were no big ad campaigns, no Marlboro Man, no Joe Camel. And there wasn't any lung cancer. You're going to hear evidence in this case about the rarity of lung cancer in this country before the mass production and mass marketing and rise of the modern cigarette. But then things changed. A man named Bonsack invented a machine that could roll and produce 100,000 cigarettes in 8 hours. So cigarette production went from one person who could hand roll maybe 200 cigarettes a day to a machine that could produce 100,000 in an 8-hour period. When they were hand rolled, cigarettes were much more expensive and harder to find. When they became machine rolled, they could be produced by the millions, and they became much cheaper and available to everyone. And then the mass production of safety matches began. It used to be that the matches that you had could spontaneously combust by themselves. They weren't like the matches we have today where they don't light until you strike them. The matches, the safety matches that you can light by striking, began being mass produced. And then the mass marketing, the advertising campaigns of the brands of cigarettes that were being produced began. And what happened was the cigarette consumption in this country took off. And you'll learn that modern mass-produced cigarettes aren't just chopped up tobacco rolled up in paper. Evidence is going to show you that modern cigarettes from 1913 onward to today are highly engineered, sophisticated nicotine delivery devices, because nicotine is addictive, especially when it's inhaled. And cigarettes, because of the new ways that had been developed of curing the tobacco and blending it and processing the different kinds of tobacco for rolling up in cigarettes, that made cigarettes inhalable, unlike cigars and pipes, which people are unable to tolerate by inhaling them. And the evidence is going to show that cigarettes are designed and intended to be inhaled. And the evidence is going to show you that inhalation produces addiction. Addiction produces repeat customers. And repeat customers produce profits. Now, the years will go by after the advent of the modern cigarette and the rise of the cigarette where everyone was using it, and repeat customers start getting lung cancer. And the question arose, does smoking cigarettes cause lung cancer? And R.J. Reynolds was paying attention to what was being said. Claude Teague was a bench chemist at R.J. Reynolds Tobacco Company who worked his way up to become a top scientist in the company. In February of 1953, Dr. Teague wrote an internal company paper for R.J. Reynolds that looked at the scientific research on the subject of whether cigarettes cause cancer. That R.J. Reynolds document from February of 1953 concludes studies of clinical data tend to confirm the relationship between heavy and prolonged tobacco smoking and incidence of cancer of the lung. The evidence is going to show you that R.J. Reynolds kept this conclusion to itself. Now, tobacco companies at that time weren't the only ones that were looking at the relationship between cigarette smoking and lung cancer. There were other scientists who weren't involved in the industry separate and apart from tobacco companies. And they wrote about and published four scientific papers that were published in the medical literature. And it was between 1951 and 1953. And they concluded that there is a relationship between lung cancer and cigarette smoking. And then newspapers got a hold of the story in the early 1950s. And Life magazine, the biggest magazine of the time, did an expose on it, complete with photographs from the lab and tumors on the backs of mice that they were painting the cigarette tar on. And Life magazine did that feature in December of 1953. And what was known in the industry as the cancer scare in the early 1950s had begun. And at that time, cigarette sales, they dipped in that time period. And the heads of the big cigarette companies, R.J. Reynolds, American Tobacco Company, Brown & Williamson Tobacco Company, Philip Morris, they saw the dip in sales, and they decided that they needed to do something about it. And so R.J. Reynolds, president, and the heads of those other companies, they all gathered for an industry meeting at the Plaza Hotel in New York City in Christmas time, 1953. And the evidence is going to show that the purpose of that meeting was to address what to do about the health information that was coming out about cigarettes and people saying that they cause lung cancer. And they wanted to reverse the dip in sales that had begun with this cancer scare. And those companies, at that meeting at the Plaza Hotel, they entered into a conspiracy to lie about the health effects of smoking and its addictive nature, and to conceal their knowledge that cigarettes were addictive and caused disease. And they did two things when they met at the Plaza Hotel. One was the evidence is going to show you that they wanted professional help as to how to deal with this dip in sales. And they didn't call on epidemiologists. They didn't call on doctors or scientists or public health experts to help them safeguard their customers' health. They hired a public relations firm, Hill & Knowlton on Madison Avenue in New York City. And the evidence is going to show you that in getting ready for that meeting at the Plaza Hotel, Hill & Knowlton went and they interviewed folks at the different tobacco company clients. And they interviewed executives, they interviewed scientists, and they interviewed marketing people at those companies. And they summed up their findings in a 1953 document called the Forwarding Memorandum. And the Forwarding Memorandum quotes the tobacco company people that the Hill & Knowlton PR folks were interviewing in advance of the Plaza Hotel meeting. It's fortunate for us that cigarettes are a habit they can't break. Said another, boy, wouldn't it be wonderful if our company was first to produce a cancer-free cigarette? What we could do to competition. And then said another, suppose everybody smoked just one cigarette less a day. That would be maybe 40 billion a year. The forwarding memo, the evidence will show, is a window into what R.J. Reynolds and the other tobacco companies knew. One is that their cigarettes cause cancer. Two, they knew their cigarettes were addictive and people couldn't stop.
Overruled.
The other thing it shows that they knew was that they needed to keep making a lot of money. And the dip in sales was affecting that. And so the PR firm laid out a plan to establish public assurance, to make people confident in smoking cigarettes, to get the sales back up. And to implement that plan, the cigarette companies created what was called the Tobacco Industry Research Committee, the TIRC. Now, they met at the Plaza Hotel in December of 53 at Christmas time. January 4, 1954 was the first Sunday of 1954. And that morning, readers of over 400, I think it's 448 newspapers across the United States, they walked out in their yard and they got their Sunday paper and they took it inside, and when they opened it up, they saw a full-page ad in the Sunday paper called A Frank Statement to Cigarette Smokers. It was published by the Tobacco Industry Research Committee, and all of those companies that participated in this conspiracy at the Plaza Hotel signed on, and their names are at the bottom of the document. It's a full-page Sunday ad. Now, the Frank statement to cigarette smokers wasn't about anybody named Frank. It was the cigarette companies were going to be frank with their customers and the American people. That they were going to be honest and sincere and mean what they say. 448 newspapers. If a paper had a big enough circulation, the Frank statement went in it. So the New York Times is one paper. The LA Times is another paper. The Miami Herald is another paper. 448 newspapers across the United States. Now the evidence is going to show you it was a different time in 1954. And newspapers may struggle today with cable news and the internet and different things that compete with newspapers. That newspapers are now struggling. But back then, newspapers were the giants. That's where people got their news. And the Frank statement went all across the United States of America at once. And the Frank statement stakes out the defendant's public position that medical research of recent years indicates many possible causes of lung cancer. That there is no agreement among the authorities regarding what the cause is. That there is no proof that cigarette smoking is one of the causes. And then they make some promises in the Frank statement to impact people's decision to smoke. We accept an interest in people's health as a basic responsibility paramount to every other consideration in our business. We believe the products we make are not injurious to health. We always have and always will cooperate closely with those whose task it is to safeguard the public health. Now, then the Frank statement, as you see here, makes an observation about the mere idea that cigarettes may pose a health risk. For more than 300 years, tobacco has given solace, relaxation, and enjoyment to mankind. At one time or another during those years, critics have held it responsible for practically every disease of the human body. One by one, these charges have been abandoned for lack of evidence. The evidence in this case is going to show that the cigarette manufacturers weren't being frank at all with the American people or with their customers. The evidence is going to show that they knew that cigarettes were addictive and caused cancer, and they were lying about it. And the evidence is going to show that they didn't accept an interest in people's health as their responsibility then, that they never intended to accept people's health as their responsibility. Now, the other thing the defendants and the other cigarette companies did at the Plaza Hotel meeting was they were going to agree to link up as one on the issue of smoking and health. They weren't going to do it individually. And they set up the Tobacco Industry Research Committee, the TIRC, to speak for them. And then in 1958, they created something called the Tobacco Institute, which was going to be a public relations arm of the tobacco industry. And then in 1964, 11 years later, they created they changed the name of the TIRC to the Council for Tobacco Research, the CTR. And going forward, it became the CTR. And the evidence in this case is going to include documents, statements, videos, and press releases from these organizations speaking on behalf of the defendant in the other companies. The TIRC, the CTR, and the Tobacco Institute spoke for R.J. Reynolds and the others. R.J. Reynolds and the other companies created and funded those organizations for that very purpose. Now, the plan the companies created at that Plaza Hotel meeting, they carried out that plan for the next 50 years. And during that time, they publicly denied that cigarettes cause disease, when privately they acknowledged that they knew that they did. During that time, they attacked the public health researchers as being dishonest and biased. The public health message about cigarettes causing cancer, the defendant and the other companies attacked it as a lie. They questioned the validity of the science when the evidence would show that the defendant and the other companies knew there wasn't any question. And they questioned the proof that cigarettes cause cancer when they knew that it was true. What they did was they created a controversy about whether cigarettes cause disease. It was a controversy that in science did not exist. And what will the evidence show about why they did that? They did it for money, profits, to keep addicted smokers smoking and buying cigarettes. Because the evidence will show that what Reynolds and the other companies knew was if someone is addicted, it isn't very difficult to convince that person to keep doing what they're addicted to by telling them there's nothing wrong with it. And so their public message was doubt, that there's no proof it causes cancer. People have been blaming tobacco for 300 years, and one by one those claims have been abandoned for lack of evidence, and this is one more such claim. They said there was no proof that cigarettes were bad for you, and if anything in cigarettes was ever discovered to be bad, they were going to take it out. And they put filters on cigarettes to reassure the concerned smokers. And if you look at the dip, after they put filters on to reassure concerned smokers, cigarette consumption went right back up and continued to climb. And the evidence will show that what the industry did, what the defendant and the other companies did to carry out their plan, was to create false doubt about the health hazards of cigarettes, to bribe respected scientists with lucrative research grants, to suppress the truth about the dangers of smoking, and they supported fake science that threw cold water on the idea that cigarettes cause disease. And so what did they say?
They said was, other things. Other things cause lung cancer. Not cigarettes. And they said the cancer comes from somewhere else. Not the lungs. And they said they were blaming medical technology. That it just wasn't as good back in the old days. And then the technology by the 50s and 60s was much better. And they were detecting lung cancer now that had been there all along. There really wasn't any rising. And the last thing they would say is nicotine in cigarettes, it isn't that addictive. Smokers just like it. And what they did was they denied that nicotine was addictive until about 14 years ago. The evidence is going to show that not so long ago, there were published reports relating lung cancer to things like rain, viruses, exhaust fumes, baldness in men, even being born in March. R.J. Reynolds did that. They did it for 50 years. I'm going to start with cancer. The evidence is going to show that privately, internally within the company, R.J. Reynolds knew that cigarettes were dangerous and caused cancer. In 1962, a scientist by the name of Alan Rodgman, who was an R.J. Reynolds chemist, wrote a paper for the company called, an internal paper called The Smoking and Health Problem, an Objective and Critical Appraisal. This is 9 years after the Frank statement, 9 years after the Plaza Hotel meeting. Obviously, the amount of evidence accumulated to indict cigarette smoke as a health hazard is overwhelming. The evidence challenging such an indictment is scant. And then Dr. Rodgman poses a question to the company about withholding the information that they know about cigarettes causing lung cancer. He says, can the company justifiably assume the position that publication of data pertaining to cigarette smoke composition or physiological properties should be withheld
because such data might affect adversely the company's economic status, when the company has already implied in its plea that no such etiologic or causative effect exists. Adversely affect the company's economic status. Money. The evidence will show that what they told the public was the opposite of what they knew to be true, over and over and over again for 50 years. They did that for the rest of Mr. Wilcox's life. The Surgeon General of the United States is the top public health official in this country, and the Surgeon General issues a report on smoking and health every year, and each report has a different topic. There's a topic on lung cancer in men, which was the first one in 1964. There's a topic another year about how cigarettes cause emphysema or COPD. Another year there's one on secondhand smoke and how that causes harm to people. Another year there's one on the harms of marketing cigarettes to children.
Objection, Your Honor.
The objection is overruled. Please continue.
The first Surgeon General report was commissioned by President John F. Kennedy in the early 1960s. And cigarette companies were asked to submit their own internal scientific data to the Surgeon General in order to assist and cooperate with the public health authorities like they had promised to do back in the Frank Statement in January 4, 1954. And what were the company's plans for cooperating? What did their internal science say? Well, internal science says that carcinogens are found in practically every class of compounds in smoke. This is 1961. Present technology does not permit selective filtration of particulate smoke. There's cancer in the cigarette smoke, and you can't change it with filters. You can't take it out. What do they tell the Surgeon General? 1963. They submitted a compendium of the chemical constituents in tobacco and smoke, and they told the Surgeon General, none of the chemical substances listed therein, to our knowledge, has been found by scientific research to be harmful to the health of the smoker in amounts reported in smoke. It is possible, of course, to modify the chemical composition of cigarette smoke by the use of filters. What they told themselves was, carcinogens are in the smoke and you can't change it with filters. Then they tell the Surgeon General exactly the opposite. Now, the first Surgeon General report was published in 1964, January of 1964, and it concluded that smoking cigarettes causes lung cancer in men. And it was one of the biggest news stories of the 20th century. The evidence is going to show you that. And the evidence is going to show that for years, people suspected that cigarettes might make you cough, it might make you short of breath, what they said, cut your wind. Even the cigarette advertisements you're going to see in this case said things like, not a cough in a carload, or they don't cut your wind. But making you cough, or making you short of breath because you've been smoking a long time, is a whole different ballgame, the evidence is going to show, than saying that cigarettes cause tumors to grow inside your lungs. That was a very different concept to the American people. So when the 1964 Surgeon General report came out and said that cigarettes cause lung cancer, it was a huge story, one of the biggest news stories of the century. And it was a big news story, the evidence will show, because if everyone already knew it, it wouldn't have been news. In America, though, it was big news. And the cigarette sales took a dip again when the Surgeon General report came out. But again, it was temporary, and smokers went right back to smoking. They went right back to smoking because inhalation produces addiction, addiction produces repeat customers, and repeat customers produce profits. 4 years after that Surgeon General report, 1968, the Tobacco Institute did an internal memo, a secret document that hadn't been seen for years. And it says our basic position in the cigarette controversy is subject to the charge and may be subject to a finding that we are making false or misleading statements to promote the sale of cigarettes. The evidence is going to show that R.J. Reynolds and the other companies had no intention of looking out for the health of their customers or telling their customers the truth about what they knew about cigarettes. Instead, they gave smokers alternatives to quitting. They put filters on cigarettes. You're going to learn in this trial that filters don't make cigarettes any safer, but they advertised them like they did. You'll see that they came out with filtered cigarettes like Salem. And by the mid-1970s, 90% of smokers had switched to filtered cigarettes. Mr. Wilcox was one of those smokers who switched to filtered cigarettes and smoked Salem. And in the 1970s, the cigarette companies then came out with another idea, that they came out with things like health brands and light cigarettes. And light cigarettes, you'll learn in this trial, aren't any safer than regular cigarettes, but the companies advertised them like they were too. So when a smoker was addicted and struggling to quit, they could switch to light cigarettes instead of quitting, because lights were advertised to be healthier. Mr. Wilcox was one of the smokers who switched to light cigarettes. He smoked Salem lights after they came out. As I told you, the Surgeon General issues a report every year on smoking and health, and the Surgeon General releases that report around the same time. They have a release date, and the companies knew when the Surgeon General was going to release a report. And through their mouthpiece, through the Tobacco Institute or the TIRC, they'd attack the Surgeon General's report. They'd issue press releases, they'd call a press conference, they'd say the Surgeon General is wrong, the science is not valid. And you'll see from the evidence in this case that sometimes they'd even call the press conference the day before the Surgeon General report came out to attack a report they hadn't even seen yet, just so they could preempt the Surgeon General's message on television and in the newspapers. In 1957, 3 years after the Plaza Hotel meetings, after they published the Frank statement, the Surgeon General issued a statement about smoking and health. And the TIRC immediately, the Tobacco Industry Research Committee immediately released a press release that said the statement issued today by the Surgeon General adds nothing new to what has been known about the cause of lung cancer. It reflects the opinions of some statisticians and the relatively few experimental scientists who have actively charged that cigarette smoking is a cause of lung cancer. This research thus far has produced no evidence that cigarette smoking or other tobacco use contributes to the origin of lung cancer. In this trial, you're going to see a pattern from R.J. Reynolds and the other cigarette makers, that what they say publicly is very different from what they say to themselves privately. And you're going to see that what they say is very different from what they do. You'll see that these companies' attack on public health authorities hasn't ended yet.
Objection, Your Honor.
Sustained.
1968, the Tobacco Institute released a press release attacking the Task Force for Smoking and Health, the report.
I apologize, but we need to make a motion at sidebar.
Counsels, you may approach. appeals. Mr. Epperson, go ahead.
Yes, ma'am. Thank you. Please support. 1968, the Tobacco Institute released a press release attacking the Task Force for Smoking and Health, a U.S. government agency that was assigned to getting the word out about the dangers of smoking. And they called the report as a shockingly intemperate defamation of an industry which has led the way in medical research to seek answers in the cigarette controversy. And the evidence is going to show you the only controversy that existed was the one the defendant created, which they knew privately didn't exist. This was 15 years after the Frank statement. 1972, February 26, Tobacco Institute releases another press release. And they said the 1972 report of the Surgeon General to Congress on smoking and health insults the scientific community, and that the number one health problem is not cigarette smoking, but is the extent to which public health officials may knowingly mislead the American public. There's no proof. It's experimental science. They're defaming us, and they're lying to you. That was the cigarette company's message. And what's the evidence going to be about how well this program was working for the cigarette companies? Well, 1972, a previously secret memo from the Tobacco Institute was 19 years after the Plaza Hotel meeting. For nearly 20 years, this industry has employed a single strategy to defend itself on three major fronts. While the strategy was brilliantly conceived and executed over the years, helping us win important battles, it is only fair to say that it is not, nor was it intended to be, a vehicle for victory. On the contrary, it has always been a holding strategy, consisting of creating doubt about the health charge without actually denying it, advocating the public's right to smoke without actually urging them to take up the practice. The evidence is going to show that among themselves, the cigarette companies congratulated one another on how smart they were and how well they pulled it off and how successful they were in executing their plan. 1979 was the 15-year anniversary of the first Surgeon General's report, the one that said it caused lung cancer in men. On that anniversary, the Tobacco Institute published a white paper, and they sent it out to the public. Smoking and Health, 1964 to 1979, the continuing controversy. And it attacked the conclusions. No one knows why or how a cancerous growth begins, whether it is in the lung, pancreas, or bladder. And then they said the claim that cigarette smoking causes lung cancer has not been scientifically proven. 1979. And they were saying it doesn't start in the lung, it starts elsewhere, and it hadn't been proven that it even causes lung cancer. The Surgeon General report was released the day after this press release. They attacked the Surgeon General report they hadn't even seen yet. And they were running public service announcements on TV calling into question the public health message about cigarettes causing disease.
Here in Washington, a lot goes on that you never hear about. Take the controversy about cigarettes. In the 91st Congress, a House committee heard testimony from leading experts on smoking and health. The record shows that many of the country's most respected doctors openly challenged anti-cigarette claims. A California doctor said, as a scientist, I find no persuasive evidence that cigarette smoking causes lung cancer. A New York doctor told Congress to claim there is now sufficient scientific evidence to establish that cigarette smoking causes disease is, in my opinion, unjustified. There is another side to the cigarette controversy. It's all here in this white paper. Send for it.
The evidence is going to show that R.J. Reynolds even prevented its own scientists from working on making a safer cigarette. December 13, 1982, R.J. Reynolds hired a new scientist, Dr. DeMarco. And it says that during his law department orientation, he said that he thinks it is essential for our...
We have an objection to this document.
Okay. Can you all come sidebar?
please, Court. As I was saying, when they hired this new scientist, Dr. DeMarco, during his law department orientation, he said that he thinks it is essential for R&D, research and development, to work on the development of a less mutagenic cigarette, one that doesn't cause cancer. He believes that this is the prudent, responsible thing to do, but has been told by the lawyers, Ed Jacob, that he can't do this work. And the evidence is going to show you that when the tobacco industry was quoting these doctors that they have in their white paper on the Capitol steps that we just showed you, that all these medical witnesses doubted the link between cigarette smoking and cancer. Dr. DeMarco, he also said, although I can't recall his exact words, that our medical scientific witnesses will say whatever we want them to say, clearly implying, if not stating, that they lacked credibility and integrity. The evidence is going to show you that the plan they conceived at the Plaza Hotel with that public relations firm was executed for the rest of Mr. Wilcox's life when he died in 1994, and it was successful. And the evidence is going to show that the reason for their success is that smokers are addicted to nicotine. Their campaign was designed to give addicted smokers a psychological crutch to keep smoking. Nicotine is the highly addictive drug in cigarettes, and it's why people smoke. That's what the evidence is going to show you. Now, I've talked to you some about what they knew about lung cancer. Now I'm going to talk to you about what they knew about addiction and what the evidence is going to show about that. July 1963. This is 10 years after the Plaza Hotel meeting. An internal, previously secret document. Moreover, nicotine is addictive. We are then in the business of selling nicotine, an addictive drug effective in the release of stress mechanisms. But cigarettes, we will assume the Surgeon General's committee to say, despite the beneficent effect of nicotine, have certain unattractive side effects. They cause or predispose to lung cancer. They contribute to certain cardiovascular disorders. They may well be truly causative in emphysema, etc., etc. That's what they said to themselves. They said the opposite in public. Now, Claude Teague, who did that memo in February 1953 for R.J. Reynolds saying that the evidence showed that cigarette smoking caused cancer, Claude Teague had moved up the ladder at R.J. Reynolds in the intervening years. And in 1972, he wrote another secret confidential document for R.J. Reynolds called Research Planning Memorandum on the Nature of the Tobacco Business and the Crucial Role of Nicotine Therein. And he says, happily for the tobacco industry, nicotine is both habituating and unique. And then he says, if nicotine is the sine qua non of tobacco products, and tobacco products are recognized as being attractive dosage forms of nicotine, then it is logical to design our products and, where possible, our advertising around nicotine delivery. Nicotine is the sine qua non, without which it would not exist. The evidence will show that while Reynolds knew the importance of nicotine to their business, they knew their customers were not aware of that. 1979, another previously secret document. Very few customers are aware of the effects of nicotine, i.e. its addictive nature, and that nicotine is a poison. And then a previously secret document from the very next year, 1980, from Claude Teague again. It sums up the result of nicotine addiction. Most of those who have smoked for any significant time would like to stop. Many, but not most of those who would like to stop smoking are able to do so. Most can't quit. And then in 1994, the evidence will show that the presidents of R.J. Reynolds and the other companies went before the United States Congress and testified under oath that nicotine is not addictive and we don't know what causes cancer. 1994. You'll learn in this trial that Reynolds and the other companies not only recognized that nicotine is addictive, they experimented with ways to add things to cigarettes to try to increase nicotine's hold on the smoker. And they discovered that adding things like urea, urine, ammonia, diammonium phosphate, if you added those things to cigarettes, it would change the pH level of the smoke, and it could make unbound or free nicotine so that the smoker would freebase nicotine to their brain. 1973, R.J. Reynolds documented a historical review of smoke pH data and sales trends for competitive brand filter cigarettes. Relatively complete pH data were available for the years 1964 to 1972 for Winston, Salem, Marlboro, Kool, Kent, and Viceroy cigarettes. And then it says the results of these studies show that there is a very strong positive correlation between smoke pH and sales trends over the years studied. A high pH smoke is strong due to a high concentration of unbound or free nicotine in the smoke. And then it talks about free or unbound nicotine. As the smoke pH is increased, the amount of free nicotine in the smoke increases. And it says since the unbound nicotine is very much more active physiologically and much faster acting than the bound nicotine, the smoke at a high pH seems to be strong in nicotine. And then 4 months later, R.J. Reynolds has a research planning memorandum on the effects of ammonia and its salts on smoke quality. And they address how it affects pH. Recent investigations indicate that natural or added ammonia and its salts in tobacco and smoke play an important role in determining the acidity or alkalinity, pH, of the smoke. This in turn determines the amounts of free and combined nicotine present in smoke, which strongly influence the way in which the nicotine is perceived by the smoker. Thus, as the amount of ammonia or ammonium salts in smoke increases above a certain level, the smoke becomes less acidic, more nicotine occurs in free, volatile, rapidly absorbed form, and the nicotine impact is enhanced. The nicotine impact is enhanced. The evidence will be R.J. Reynolds employs ammonia technology, employed the technology to the cigarettes for decades. And you'll learn that they can remove nicotine from their cigarettes, and they choose not to, because nicotine is addictive. Addiction keeps smokers smoking. Addiction keeps smokers from quitting. And in their secret confidential documents, they acknowledge why they didn't want anyone to recognize the importance of nicotine addiction. September 1980, previously secret Tobacco Institute document. The entire matter of addiction is the most potent weapon a prosecuting attorney can have in a lung cancer cigarette case. We can't defend continued smoking as free choice if the person was addicted. The evidence will show that while they acknowledge that in private, in public, Reynolds would say that smoking is all just a choice by the smokers, it's all the smokers' behavior. The evidence will show that Reynolds had the choice to tell the truth about what it knew, and they chose not to for 50 years. They chose not to because they wanted more money. The evidence will show that they didn't just focus on nicotine addiction either. They were also creating an environment where smoking was perceived as normal. Because the evidence is going to show you that the rise of every popular brand of cigarette depended on its popularity with young people. Reynolds focused on it. They studied it. They knew, and you're going to see from the evidence, that the majority of smokers start as minors, as kids. And you'll learn that 80% of males in Mr. Wilcox's birth cohort, in his generation, 80% of them, 4 out of 5, grew up to be smokers. 4 out of 5. The evidence is going to show you it would have been unusual if Mr. Wilcox wasn't a smoker. The environment that he grew up in, R.J. Reynolds marketed to young people, to school-age kids, and studied how selling cigarettes to children was the key to their business. Their own files received how they advertised to youth back when Mr. Wilcox was a boy. School days are here. That means big tobacco business for somebody. Let's get it and start after it right now. Give every school a good working just as quick as possible after it opens. Line up the leaders and the most popular students. In other words, get off to a good start just as quick as you can, and then keep up this work at regular intervals. Now, in a retrospective look back to the days of Mr. Wilcox's childhood, there's an R.J. Reynolds management study called a Secret Strategic Report. Younger adult smokers, strategies, and opportunities. This is a 1984 document that's a 50-year retrospective. The importance of younger adult smokers. Younger adult smokers have been the critical factor in the growth and decline of every major brand and company over the last 50 years. They will continue to be just as important to brands and companies in the future for two simple reasons. The renewal of the market stems almost entirely from 18-year-old smokers. No more than 5% start after the age of 24. And then the brand loyalty of 18-year-old smokers far outweighs any tendency to switch with age. Now, what did R.J. Reynolds consider in this document to be a younger adult smoker? Appendix B tells us, ages 12 to 24. And then they talk about, in this document, why it is, if you go to the next one, why then are younger adult smokers important to RJR? Younger adult smokers are the only source of replacement smokers. Less than one-third start after 18. Only 5% start after age 24. If younger adults turn away from smoking, the industry must decline, just as a population which does not give birth will eventually dwindle. R.J. Reynolds and the other companies did everything they could to cause young people to become smokers when Mr. Wilcox was a child. Their ads show war heroes, more doctors smoke Camels, movie stars like John Wayne, Santa Claus buying Camel cigarettes, doctors advertising Lucky Strikes as less irritating, teaching people how to inhale with advertisements. Sports stars like Joe DiMaggio are advertising these cigarettes, and through marketing and advertising, they created an environment in which smoking was a normal, everyday thing to do. Even like a rite of passage for a boy like young Cleston Wilcox. They put cigarettes in vending machines that were available to anyone at any age who was big enough to pull the lever, just like a Coke. That was the world in which 8-year-old Cleston Roy Wilcox began smoking in 1932. They called him Red. There is no photograph of him as a child because he didn't grow up in that kind of home. He was born in the Mississippi River Valley outside St. Louis, and he was one of two sons born to George and Beatrice Wilcox. His mother died in childbirth when he was 2 years old. And he spent his childhood going back and forth between his father's house and his aunt's house. And he worked at a grocery store, delivering groceries. And when the United States was bombed at Pearl Harbor in December 1941, young Red Wilcox went with his father to the Marine Corps recruiting station and signed up for the Marines the very next month. He started out as a rifleman in the Marines. And he fought in the Pacific Theater at the consolidation of the Solomon Islands, the Marianas invasion, and then he fought in the longest, bloodiest battle of the Pacific Theater in World War II, the Battle of Okinawa. And when World War II ended, Mr. Wilcox was wounded in Japan when a Japanese grenade exploded near his hand. And he was shipped stateside for surgery. And he went to the Great Lakes Naval Hospital in Chicago to have surgery and to rehabilitate his hand. And he was cared for by a pretty young nurse assistant by the name of Lorraine Swinarski. And it was the beginning of a courtship and marriage that lasted 48 years. Red Wilcox's life, you'll learn, is a story of wonder. He was an intelligent man who never got past the 8th grade in school, who became a leader in a career with the Marine Corps, and then another career at Eastern Airlines after he retired from the Marines. He suffered an explosion injury to his hand from that grenade that was so severe it was feared that he would lose the use of that hand at all, but he overcame that, and he earned a living with that hand his entire life. And he may have lost his mother at 2 and shuttled back and forth between his family members, but he overcame that and became a loving, devoted husband and father who raised 2 boys that any father would be proud of, and he married a woman that any man would be lucky to spend his life with. And you'll learn that through intelligence and hard work, and motivation and love, Mr. Wilcox overcame every obstacle that he met in life. The only one he couldn't overcome was nicotine addiction, and that addiction took him before his time. Red Wilcox was 17 when he enlisted in the Marine Corps in January 1942. At that time, he had already been smoking for 9 years. He was born in 1924, and the medical records in this case tell us he started smoking when he was 8 in 1932. And then he smoked a pack or more a day for 34 years before the first caution label was forced on R.J. Reynolds and the other companies in 1966. And he died from lung cancer in 1994 after major surgery to remove his left lung, and he was 69 years old. The evidence is going to show that he lived his life here from 1963 on. He lived in Miami. He died at Baptist Hospital January 19, 1994. He smoked Camel cigarettes, he smoked Salem cigarettes, and he smoked Salem Light cigarettes, all made by Reynolds. He smoked Lucky Strike cigarettes early on, made by American Tobacco, but American Tobacco merged with Brown & Williamson, and then Brown & Williamson merged with R.J. Reynolds, and so R.J. Reynolds is Brown & Williamson and American Tobacco and all the brands they made. Every Lucky Strike, every Camel, every Salem Light that Mr. Wilcox ever smoked contained nicotine and was addictive. Every single one of those cigarettes caused lung cancer. And you're not going to hear any dispute today from R.J. Reynolds that those cigarettes contain nicotine and are dangerous and addictive and cause cancer. They concede that now. But you'll see from the evidence that while they had known that to be true for decades, they designed and manufactured their cigarettes to be addicted, and they lied about it every day of his life. Today it might seem strange that someone would smoke cigarettes when they're 8 years old. But it was a very different time in 1932. There weren't any warnings on packs, and there wouldn't be for many years. There wasn't any no smoking signs in courtrooms back then. It wasn't a federal crime to light a cigarette on an airline flight. And the evidence is going to show that the decision to start smoking cigarettes in the 1930s is very, very different from a decision to start smoking today. The way more dentists use Crest today, more doctors smoked Camels back then. The doctors, the war heroes, and movie stars, cigarettes were how boys tried to look like men. It was a very different time. Back then, Her Honor could be smoking right now while I give this opening statement. Y'all can have ashtrays lined up in front of you, smoking away. All these folks sitting out here in these pews could be smoking. You could smoke in the movie theater. You could smoke in the hospital. You could smoke when you were pregnant, and no one would bat an eye. When Lorraine met Red Wilcox, he was a patient in the Great Lakes Naval Hospital where she worked, and he was smoking cigarettes in bed when she met him. It was a normal thing to do. He was honorably discharged from the Marine Corps in 1946, and he and Lorraine married. They moved to St. Louis. They lived there for a year and a half or so, but he loved the Marine Corps, and he re-enlisted in 1948. And their first child, Michael, was born that year in 1948. And Mr. Wilcox worked the next 15 years as a Marine Corps aircraft mechanic, and he retired from the Marines in 1963. And what kind of man was he? You're going to have over 500 pages of United States Marine Corps records and evidence in this case, and there are over 1,700 pages of medical records going back to the 1980s. You're going to see that they chronicle a career of service to this country. Presidential Unit Citation for service at Okinawa, World War II Victory Medal, Asiatic Pacific Campaign Medal, Korean Service Medal, 6 Good Conduct Awards. You're going to see performance reviews describing him and what kind of personality he was. You're going to see one that says Acting Gunnery Sergeant Wilcox is a pleasant, spirited, and stable NCO, non-commissioned officer, who readily accepts responsibility, applies himself to his duties with enthusiasm and determination, producing highly satisfactory results. He's highly informed technically and is capable of performing any duties assigned with confidence. Acting Gunnery Sergeant Wilcox takes pride in accomplishing a difficult task. He wasn't educated, but he was intelligent, he was motivated, and he was accomplished. At the age of 38 in 1962, a man with an 8th grade education went and got his GED before he retired from the Marine Corps, the equivalent of a high school diploma. He retired from the Marines in '63, lived here in Miami, and worked for Eastern Airlines. And then in 1966, he and Ms. Wilcox had their second son, Robert. And Robert was appointed by the court to be the personal representative of his father's estate, and he's the plaintiff in this case. He's the only one in this courtroom right now that you're going to hear testify. All the other witnesses, including Robert's mother, aren't allowed to be in here until it's time for them to testify. And that's why she's not here today watching this opening statement and participating. You're not going to hear one single bad thing about Cleston Roy Wilcox in this case, not one. In the early 1970s, Mr. Wilcox suffered a heart attack, and he recovered, but his doctor told him he ought to stop smoking. And he tried to stop, but he was unable to. So he switched brands. He was smoking unfiltered Camel that he'd been smoking for 27 years, and he switched to Salem with a filter. Now, one of the things the evidence is going to show is the way cigarettes are perceived today is very different from how they were perceived back in the 30s, the 40s, all the way into the 90s. While it might seem inconceivable today that anyone ever doubted cigarettes were dangerous and addictive, the evidence is going to show Reynolds and the others ran a successful 50-year campaign to say that they weren't. And while the government and public health authorities were trying to get the word out about the dangers of cigarettes, the industry, including Reynolds and the others, they spent more money on their message in one day than the U.S. government spent on its message in 1 year. Hundreds of times more the company spent. You're going to learn that the Surgeon General of the United States determined nicotine in cigarettes was addictive in 1988. That was just 6 years before Mr. Wilcox died. The cigarette company's message all those years had worked. The evidence is going to show that when the dangers of smoking became a subject of public discussion in the 50s, they put filters on cigarettes, and within 10 years, half the smokers were smoking filtered cigarettes. And within the next 10 years, 90% of the smokers, including Mr. Wilcox, were smoking filtered cigarettes. And then they started making light cigarettes in the 70s, and Mr. Wilcox switched to them too. The evidence is going to be that those filtered and light cigarettes are just as dangerous, just as addictive, cause just as much lung cancer as the old unfiltered Lucky Strikes and Camels. And R.J. Reynolds didn't admit that the whole time Mr. Wilcox was alive. It was inconceivable then that a company would make a product that was addictive and could kill you if you used it long enough and lie about it. That's what R.J. Reynolds did for 50 years. And you're going to learn in this trial that one of the hallmark signs of nicotine addiction is being unable to quit even after you're diagnosed with a disease that's either caused by smoking or can be made worse by smoking. Hallmark sign. Mr. Wilcox's medical records document a patient with those signs. He was unable to quit smoking after his heart attack in the 70s, and we don't have medical records going back to the 70s. We only have records going back to 1985 or 86. But in December 1988, Mr. Wilcox was hospitalized with chest pain. He didn't have a heart attack, but he was in the hospital getting worked up. Says he has been off cigarettes now for 3 days in the hospital, and we are hoping that he will maintain the tobacco abstinence on the outside. This was strongly suggested. He tried to get off cigarettes, and he cut down to 10 cigarettes a day, but he couldn't get down to 0. January 1989, he's hospitalized at Baptist for dizziness and shortness of breath. The patient on the afternoon of January 29 basically felt miserable, probably secondary to nicotine withdrawal. He says that he had a strong craving for tobacco. You'll see records that he was agitated, nervous, and wanted a cigarette in the hospital. May 1989, he had a pulmonary function test where he's told he didn't have COP yet, but he did have some airways disease, and if he kept smoking, he was going to get emphysema. Still couldn't quit. He was diagnosed with an abdominal aortic aneurysm and went to Baptist Hospital for 2 weeks to have major surgery for that and was told to stop smoking again. And he tried. By January 1990, he cut down to 1/2 pack per day. But then, by September of 1990, he couldn't cut down anymore, and he actually went up to 3/4 of a pack per day, and had been smoking 60 years. In 1991, the Food and Drug Administration, the FDA, approved nicotine patches that smokers could put on their arm as a nicotine replacement therapy. You'll learn in this trial that nicotine patches, like nicotine gum back then, were prescription-only medications. You'll learn in this trial that in order to get that prescription, some doctor had to prescribe it for you because you were addicted. Nicotine replacement therapy. Mr. Wilcox got a prescription for nicotine gum in the 80s, but he was only able to cut down and couldn't quit. He used the patches as soon as they came out. He was so excited about having a patch to help him quit that he told all his friends he's going to quit using the patch. And in 1992, when he got it, he was finally able to quit using that patch and got down to 0 cigarettes a day. And then Hurricane Andrew hit. It was August 24, 1992, and the Wilcoxes lived in a trailer in Southwest Gate. And if you were here then, you know what happened out there. They lost their home. It was gone. And Mr. Wilcox started smoking again. But even then, he was trying to quit. This record from September 1992 shows that he was smoking 5 cigarettes a day. He was still trying to work to get off cigarettes. But what's the evidence going to be in this case about what it means to smoke a pack of cigarettes a day for 60 years? What does that do? What does that expose you to? It's repeated dosing of nicotine, a highly addictive drug, every day, hundreds of times a day for 60 years. You'll see here that Mr. Wilcox at 1 pack a day would be 7,300 cigarettes a year. It's 20 cigarettes in a pack, 20 cigarettes a day for a year, 7,300 cigarettes. You get 10 puffs per cigarette. That's 10 doses of nicotine. He would get 73,000 doses of nicotine in a year. 73.
7,300.
So he would get 73,000 doses of nicotine every year that he smoked a pack a day. And he had 4,380,000 lifetime exposures to all the carcinogens that come with the nicotine. Over and over and over again. You know, he tried to quit many times, and like those who try and fail, Mr. Wilcox wanted to quit so badly that he tried all the methods that were out there. He tried cold turkey. He tried cutting back. He tried smoking half the cigarette instead of the whole cigarette. He used a thing called an aqua filter that you could buy at the drugstore that they sold over the counter, that you would put on your cigarette and smoke your cigarette through the aqua filter. He went to a hypnotist. He sought medical help. He got a prescription for nicotine gum and he got a prescription for nicotine patches. And the evidence is going to show he tried to quit smoking repeatedly. And that's how nicotine addiction works. It is a chronic, relapsing disorder. Many, but not most of those who would like to stop smoking are able to do so. He was addicted for decades before the first caution label went on a pack of cigarettes. So the first issue you're going to decide in this case is whether he was a member of the Engle class. He died 5 years before the 1999 Engle trial, and the Supreme Court in 2006 made rulings that the Engle class are those people who suffered or died from lung cancer caused by their addiction to nicotine and cigarettes before November 21, 1996. He died in January 1994, and there's not going to be any dispute that he was a Florida resident and died before that date. The only issue you're going to need to decide was his death the result of lung cancer caused by an addiction to nicotine contained in cigarettes. And you're going to be told that, was his addiction a legal cause? And you'll see it says a legal cause of his death, not the legal cause. And that's an important distinction because cigarette addiction doesn't need to be the only cause. You're able to find that Reynolds' concealment of the truth was a cause, that Reynolds' conspiracy to conceal the truth was a cause, that Reynolds' negligence...
Objection, Your Honor. This diverges from Your Honor's instructions this morning.
Sustained.
Move to strike.
Granted.
In order to find Mr. Wilcox a member of the class, you don't need to find Reynolds 100% responsible. You only need to find that R.J. Reynolds contributed to his addiction and death. And if you find by the greater weight of the evidence...
Same objection, Your Honor.
Sustained.
You're just right.
Sustained. Granted.
If you find by the greater weight of the evidence that he was a member of the Engle class, then the Engle findings apply. And those findings, if you find him to be a member of the Engle class, will be binding on the court and the parties and the jury. And those findings are that smoking causes numerous diseases, including lung cancer. Nicotine in cigarettes is addictive. R.J. Reynolds Tobacco Company was negligent. R.J. Reynolds Tobacco Company placed cigarettes on the market that were defective and unreasonably dangerous. R.J. Reynolds Tobacco Company concealed or omitted material information not otherwise known or available, knowing the material was false and misleading, or failed to disclose the material fact concerning the health effects and or addictive nature of smoking cigarettes, and that Reynolds entered into an agreement to conceal or omit information regarding the health effects of cigarettes or their addictive nature with the intention that smokers and the public would rely on this information to their detriment. And because those findings were already established, it's not the task of this jury to decide those things. Your task is to decide whether he was a member of the Engle class first. And then if you do, that these findings would then become binding on the jury and the court. And with regard to Engle class membership, the evidence is going to show Mr. Wilcox had adenocarcinoma of the lung, a type of lung cancer caused by smoking cigarettes made by Reynolds. And the evidence is going to show that Mr. Wilcox had a 60-year history of smoking every day when he wasn't trying to quit or cut back. You're going to see 1988, patient gives a rather dramatic 55-year history of tobacco use. 1989, 1 pack per day for 55 years. 1993, the patient who smokes 1 pack per day of cigarettes for 60 years since the age of 8 and is still smoking. The evidence will show there are dozens of cancer-causing compounds in cigarette smoke, so when a person inhales that smoke to get their required dose of nicotine, all those carcinogens come with it. In October of 1993, Mr. Wilcox had an upper respiratory infection. He went to his family doctor, and that doctor sent him to have a chest x-ray. And the chest x-ray says that he was a patient with a cough and is a smoker. And it says there's a nodular density projecting in the lateral aspect of the left lung and the central third. This nodule is a new finding when compared with previous exams dating back to May of 93 and July of 91. With his history of smoking 60 years and having a new nodule in his left lung, Mr. Wilcox was referred to a lung specialist, a pulmonologist by the name of Dr. Juan Barrio. And Dr. Barrio saw Mr. Wilcox, and he did an extensive history and physical exam. It's 4 pages long. But he interviewed Mr. Wilcox, and he reviewed his records to see whether he had been exposed to anything that caused this problem. And he found that his occupational history was non-contributory. His personal history was non-contributory. His family history was non-contributory, but that he had smoked cigarettes for 60 years. And he sent Mr. Wilcox to have a CAT scan of the chest on November 11, and it showed a 1.2 centimeter peripheral nodule in the left lower lobe correlating with the chest x-ray abnormality. Same nodule, same place. And later that month, Dr. Barrio sent Mr. Wilcox to Baptist Hospital to have a needle biopsy where they took a long needle and they inserted it through his chest between his ribs and into his lung to get a sample of that nodule that was in his lung. And they took it and sent it to the pathologist, this very small piece of tissue, and the pathologist diagnosed it as carcinoma, non-small cell type, most consistent with adenocarcinoma. Now, Mr. Wilcox, you'll learn, had no signs of cancer anywhere else. And if the lung cancer hadn't metastasized or spread to somewhere else, he could be cured by cutting that cancer out of his lung. And so they did more tests to make sure that the cancer hadn't spread and to look inside him. So they did a CT scan of his abdomen and pelvis. It was negative for metastasis. They did a CT scan of his brain. It was negative for metastasis. They did a bone scan. It was normal. It was negative. No cancer. So Mr. Wilcox had a diagnosis of lung cancer, and all the tests showed that it hadn't spread anywhere, and he had a chance to be cured if that cancer was removed. So his surgeon, Dr. Lamellis, scheduled Mr. Wilcox to have a surgery to remove it. In December 27, 1993, Mr. Wilcox was admitted to Baptist Hospital to have lung cancer surgery, and you're going to see that when he showed up at the hospital, he was wearing a nicotine patch. And Dr. Lamellis had planned on taking out a portion of Mr. Wilcox's left lung that had the cancerous nodule in it, but when he got into the surgery, you'll see that Dr. Lamellis wrote this note after he got out of surgery that day: left lung cancer with significant involvement of the left lower lobe bronchus and superior, mediastinal, and subcarinal lymph nodes. You're going to find that those are the lymph nodes that lung cancer spreads to. So instead of taking out just a portion of Mr. Wilcox's left lung, Dr. Lamellis took out the whole lung and took out those lymph nodes that the cancer had spread to. And he sent it all to the pathologist. And the pathologist found the nodule that was seen on the scans, and it was 1.5 centimeters, just like all the scans showed. And it was adenocarcinoma. But he also found next to it a small 1 centimeter nodule that they hadn't seen on the scans. He looked at that, it was adenocarcinoma as well. And the removal of Mr. Wilcox's lung confirmed that he had lung cancer. Now, the removal of a whole lung is called a pneumonectomy. It's a big surgery, and it's often used today to cure lung cancer, and it carries with it a list of risks and complications. After you have your lung removed, it can cause your heart to beat erratically, and that can cause a drop in blood pressure and a lack of oxygen that then requires you to be ventilated, be put on a ventilator. And then you can cause a bronchopleural fistula to occur. It can cause adult respiratory distress syndrome, which in 1992 was almost universally fatal. Mr. Wilcox had his lung removed, and he did well for a couple of days. And his heart started beating erratically, and his blood pressure dropped, and his oxygen level dropped, and they had to put him on a ventilator. And then he got a bronchopleural fistula, and then he got adult respiratory distress syndrome, which then was fatal. And he died on January 19, 1994. He lived for 3 weeks after the surgery. Now, there's no dispute in this case that Mr. Wilcox died as a result of having extensive surgery for his lung cancer. And there's no dispute that if he didn't have cancer, he wouldn't have had that surgery. And there's no dispute in this case that if Mr. Wilcox hadn't have died from the surgical complications of treating that cancer, that the cancer would likely have killed him anyway because it had spread to his lymph nodes. It had already spread. Now, I'm charged in opening statement with telling you what the issues are and what I believe the evidence is going to show. And I believe the defendant's going to call the experts they said they were going to call. And we do this thing before trial where we go take everyone's sworn testimony so we know what they're going to say. They know what our folks are going to say. And I expect them to call an expert witness to testify that even though all the doctors who diagnosed Mr. Wilcox, treated him for lung cancer, and certified his cause of death as lung cancer, that those doctors were wrong, that he didn't have lung cancer. I expect Reynolds to take the position that his lung cancer may have been caused by something other than cigarette smoking.
Objection, argument, Your Honor.
Same with the evidence.
Overruled.
And even though you're going to find in this trial that there is no evidence that Mr. Wilcox was ever exposed to anything other than smoking to cause his lung cancer, I expect Reynolds to take the position that Mr. Wilcox didn't have lung cancer, that his cancer must have started somewhere else, not in the lung. I expect Reynolds to take the position that medical technology in 1992 just wasn't as good as it is today. And that if they had the stuff they had back then that they have today, they may have determined that he didn't have lung cancer. And I expect Reynolds to take the position that Mr. Wilcox wasn't addicted, that he just liked smoking, even though he tried to quit all those times. Now, the evidence in this case is that Mr. Wilcox had a biopsy-proven lung cancer and a lung cancer surgery-proven lung cancer caused by 60 years of smoking cigarettes. You're going to learn there's no evidence he was ever exposed to anything else that would have caused his lung cancer. There's no history of asbestos exposure in Mr. Wilcox. You're going to hear about interstitial lung disease or pulmonary fibrosis. And what you'll learn is there are literally thousands of things that cause interstitial fibrosis or interstitial lung disease, none of which cause lung cancer. That's what you're going to learn in this trial. Now, there are 550 pages of Marine Corps records and more than 1,700 pages of medical records, thousands of pages of witness testimony taken in this case, and there is no evidence that you will see from any source that says Mr. Wilcox was ever exposed to toxins other than cigarettes that would be responsible for causing his lung cancer. Now, there's a statistic that you're going to hear about in this case that's going to be significant, and it's just a fact, and it proves an important point about the power of nicotine addiction. You're going to find that there's tens of millions of smokers in this country. 78% of them smoke every day. 68% want to quit. 52% try to quit. Only 3% are successful long term. If you take the 97% are not successful trying to quit at any given quit attempt in a year. Only 3% do it. There are so many smokers in this country that if you add up that 3% and you go back 60 years, 60 million people have quit. That's how many smokers there were in this country, where only 3% are able to quit, and it amounts to about 1 million people a year. We're going to bring you expert witnesses to testify in this case as well in 3 areas. We're going to bring you Dr. Luis Villa, who's a board-certified pathologist and oncologist, and he's going to testify that Mr. Wilcox had lung cancer caused by smoking cigarettes, and that he died as a result of that lung cancer and the treatment for it. If Mr. Wilcox didn't have lung cancer, he wouldn't have died when he did. You're going to hear from Dr. Michael Herkov, a psychologist from Gainesville at the University of Florida, who's written on the biology of nicotine addiction in peer-reviewed scientific journals. He teaches medical students and psychology students about nicotine addiction. And he's going to testify that Mr. Wilcox satisfied numerous recognized nicotine addiction criteria and was heavily addicted to the nicotine in cigarettes. And we're also going to bring you Dr. Robert Proctor, who's a tenured professor of history at Stanford University in California. He teaches courses on tobacco and health and world history. He has written extensively on the once secret tobacco documents. He's written large books on it and numerous papers. He has published and spoken about the tobacco industry misconduct, and he was invited to be a peer reviewer for the 2014 Surgeon General's report. There are some 16 million pages of tobacco industry documents and about 3,000 videos. And we've just shown you a snapshot. There's no way that we would be able to bring you 16 million pages or 3,000 videos. We'd be here for a whole year. But what we are going to show you is what Reynolds knew and when they knew it and what they decided to do with the information they had. Now, some things that you're going to learn about cigarette design. The evidence is going to show you that cigarettes are dangerous and addictive. And Reynolds can remove nicotine from cigarettes, but they choose not to. You're going to find that Reynolds cigarette designs control the amount of nicotine in the different brands of cigarettes that they make. And that they add compounds like ammonia to cigarettes to try to increase the effect of nicotine. You're going to learn that filters don't make cigarettes safe. Lower tar doesn't make cigarettes safe. And you're going to learn Reynolds never told the public during Mr. Wilcox's life that cigarettes are dangerous and addictive, ever. You're going to learn about nicotine addiction. The nicotine addiction permanently changes the brain. The nicotine addiction interferes with the smoker's ability to carry out a decision to quit smoking. That choosing to quit is easy, but executing that choice is a struggle. And you're going to learn that nicotine addiction causes 97% of smokers to fail on any given quit attempt. And then you're going to learn about cigarette inhalability and why it's so important. Because Reynolds designed cigarettes to be inhalable. And Reynolds makes cigarettes inhalable. And Reynolds puts additives in cigarettes to make them more inhalable. And the inhalability of Reynolds' cigarettes is what makes them so addictive. The surface area of your lungs, if you took it and spread it out on the ground, could cover the area of a tennis court. The surface area inside your mouth is the size of a tennis ball. Cigars and pipes aren't inhaled. They're only taken into the mouth, and they're not nearly as addictive as cigarettes, which are inhaled into the lungs, that tennis court-sized area inside your chest. and the lungs take that nicotine and they send it to the heart, and the heart takes that nicotine and it sends it to the brain, and it gets there in less than 10 seconds from the time a cigarette smoker sucks on a cigarette to the time that nicotine hits their brain. And the brain physically changes to where it needs nicotine to function normally, because your brain has receptors in it that receive the nicotine. And when those receptors, they get to where they need the nicotine, and when they get low, the smoker feels terrible. When they fill those nicotine receptors up, the smoker, when they inhale that cigarette, they feel pleasure and they feel better. And the brain releases all kinds of chemicals when a smoker inhales the nicotine, when an addicted smoker does that. Because nicotine, you're going to learn, is an addiction that is very similar to heroin and cocaine. But it's not a crash and burn drug like heroin and cocaine. Because if the smoker doesn't get their required dose of nicotine, they feel lousy, fidgety, nervous, anxious, irritable, and relief's always right around the corner at the store. And during Mr. Wilcox's days, Reynolds never admitted there's never been a cigarette sold anywhere in the world that wasn't addictive and didn't cause cancer. And Reynolds never told the public that the reason it's so hard to give up cigarette smoking isn't because of the smoker's own behavior alone. It's because cigarettes are addictive and made to be that way. The evidence is going to show that the reason that R.J. Reynolds and the others concealed the truth and hid it from the public is because addicted people can't quit. And young people can decide not to be replacement smokers. And R.J. Reynolds and the other companies did what they could to keep that from happening. They wanted smokers to believe the reason they couldn't quit was because of their own behavior. And that Reynolds didn't want anyone to know the reason, that because 3% successfully quit, they didn't want anyone to know that that's because nicotine is addictive. And you're going to learn that if the market demands it, medical science can respond. You'll learn the Surgeon General didn't declare nicotine addictive till 1988. It wasn't until after that we got nicotine patches, nicotine lozenges, nicotine nasal spray, Chantix, Wellbutrin. All those things were created because the word got out that nicotine was addictive. You're going to learn in this case that if it weren't for the addictive modern cigarette starting in 1913, lung cancer would hardly exist in this country. Lung cancer death rate is the red line. You'll see it was so rare before 1930, they didn't even keep statistics on it. When they started keeping statistics on it, the rate of lung cancer in this country directly tracks the use and rise of cigarettes and then the fall of cigarettes after their peak in 1982. And you'll see there's a 20-year lag between the rise of the rise of cigarettes and the rise of lung cancer, because it takes time for cigarettes to cause lung cancer to occur. R.J. Reynolds and the other companies created a lung cancer epidemic in this country through the use of cigarettes. Cleston Roy Wilcox died at Baptist Hospital in Miami. He died with his family present, and they were helpless to do anything for him. And he was 69 years old. Lorraine Wilcox lost the one man she had lived her life with and made her life with for 48 years. Today, she's 90 years old, and she's blind, and she has lived alone for the last 20 years since her husband died. The evidence in this case is going to show intentional, reprehensible conduct by R.J. Reynolds Tobacco Company. You're going to learn that they did what they did with full knowledge that people were going to die. Red Wilcox was one of those people. And lastly, this is a wrongful death lawsuit. When the plaintiff proves this case, the only thing that the law allows you to do is to award money damages. You can't bring Red Wilcox back, and you can't make R.J. Reynolds Tobacco Company disappear. All you can do is award money damages. And there isn't any surprise about any of that. We're here, in this case, using the same currency that drove all the decisions that R.J. Reynolds Tobacco Company made during Cleston Roy Wilcox's lifetime.
Objection, Your Honor. Argument.
Sustained.
This case is about the truth and how they butchered it. In this case, it's about consequences and how R.J. Reynolds needs to face them. Thank you.
Same objection, Your Honor.
All right. Thank you, Mr. Gufferson. It's about lunchtime, so we're going to take a break, ladies and gentlemen, to have lunch. After lunch, you'll hear from the defense. In the meantime, please remember, as I've told you at every break, to not talk about the case, to not read anything or do any research, even amongst yourselves or with anyone else. I'm going to ask you all to come back at 1:15. All right? Victor will walk out with you and let you know where to meet him. Thank you.
All right.